I love what I do. I love this area of the law. I first felt very strongly and felt a deep connection towards it in when I took well, I've recognized the importance of it as a child, but I felt a deeper connection in law school. This idea that we could speak beyond the grave, that we could have our intent carried out, even though we may no longer be alive. I thought there was something so profound about that. As a child, I grew up with a much older generation. My grandmother was one of five. They were all born in the early 1900s. So I saw a fair amount of funerals. I saw a fair amount of relatives passing. I went to a good amount of funerals. And I noticed even at a young age, and I didn't really verbalize it or consciously recognize the pattern I was noticing, and that was some people passed and things were chaotic. There was some family drama, some terrible things that were said, some connections that were irretrievably broken. And then there were others that the person passed, we grieved, and things were very, very quiet and very different. And I later came to find out that it was the family members that had good estate planning that more often than not resolved that drama in advance. Everyone knew what was going on. This is what the person wanted. You may not like it, but that was that. So I saw the value as a young child, and was drawn to it through law school in sense. So just going to try to dive into slides. Feel free to ask any questions along the way. I'll try to make this as interactive as possible. Some great quotes from Benjamin Franklin and Winston Churchill. I don't know about some of you, but I felt like, especially the higher level estate planning was like this secret handshake thing, this language that only rich people or very wealthy people knew, and that's just not the case. That myth should be dispelled. Hopefully, by the end of this presentation, there's no great secrets. There are extremely complicated estate planning. There can be extremely complicated asset protection techniques, but we don't need to concern ourselves with that 99.9% of the time, especially with the tax circumstances currently in the United States. So we'll go through some basics, some pitfalls of probate, how to minimize family conflicts, how to get started, and we'll hopefully have a little time for Q&A. You're in the right place if you know you want an estate plan, but you're not sure where to start. You're curious about what this is all about. You may even be wondering why you can't just do this on your own or through some online website. That's all good. If you ended up here and you don't know how you got here, then you may not be in the right place. Otherwise, if you know what the topic is, you're fine. So this is some contact information. Hopefully you have that through the emails and however you found out about me or found out about this through social media. These are our full list of practice areas. It just so happened the EMRPA flow, that was an afterthought. So estate planning, mortgage foreclosure defense, real estate closings, probate and trust administration, and accidents and injuries. There's what some people have to say about me, which is very nice. So, common objections. Some of you may be thinking, well, my spouse is going to take this over anyway. Why does it matter? I'm too young. I don't have enough money. We'll cover some of that tonight, but if you have any specific concerns, you're welcome to have a free consultation with me, and I'd be glad to address those. There are times you may not need a full-blown estate plan. And if we can do what you want to do without it, and there's a few different other mechanisms available, great. If I can save you money doing it an easier way, great. But there are times that an estate plan is best. Or I should say a more detailed estate plan is best. Generally speaking, incapacity planning is always wise. And we can talk about legacy planning too. That's the three parts of estate planning, not just the stuff. But the stuff, there are other ways than a will or a trust that we're not going to get too deep into tonight, but I'll be happy to address through a follow-up consultation. So, what's the risk if you don't do it? Well, I think an easy way to answer that are what are the goals? So, you're looking to give stuff away. You're looking to care for yourself. That's the incapacity planning piece. You may want to care for others. You may want to avoid probate. That's a very common one. You may have some charitable ideas. You may want to pass on values and ideals, and there's some great ways to plan your legacy. I think that's an often underappreciated, overlooked piece of this, but it's an important one we put significant energy into. You certainly want to maximize assets, minimize taxes, protect assets. Those are all part of the things you want to do. And going back to that prior slide, things that you risk not doing without a proper estate plan. So most people think of a will. That's the most common thing. A testamentary intent, a will, that is the old-fashioned piece of paper. In Florida, you have two witnesses, you have a notary, you have a unique attestation where you can self-prove an original will. One of the few documents you still generally need an original for is a will. There's all kinds of other things that there are exceptions for lost documents, and there is a lost or destroyed will provisions as well that you can prove up, but that is tricky. So generally, the will is a snapshot of what you want to happen at your passing. If you don't have a written will or a trust, if you have nothing, you actually do have something. And that's the Florida default program that's referred to as intestacy, dying intestate. And that has a way in which things are going to go, a pecking order, if you will, your spouse, your kids, et cetera, and on down the line. There's a ton of pitfalls to that. If you have children or people you don't want to get things, they will. People who you may have taken off of property, but then you pass or a loved one passes and the intestacy puts them back on. I've seen that in cases. So putting it in writing is way better to avoid that type of thing. Someone reinvesting an interest. Kids get things outright. You may not want that. There's could be divorce and creditor issues. There could be remarriage issues. If there's minor children, then the judge gets to decide who's in control. And probate is guaranteed if there is anything that needs to be probated. Minor children is a big deal. So that's something you can name a guardian in your last will and testament. You can create a preference in a trust. There's ways you can create a successor trustee. Guardianships are not fun. I don't do guardianships. I have done them. Part of the reason I don't do them is because they are all of these things here on this. They're rigorous. They can be complicated. They're lengthy. Everything you need to get court approval for. There are inventories. There are reporting. It is definitely not for someone that doesn't like to dot their I's and cross their T's on every little thing. That is a guardianship, and rightfully so. You're dealing with someone overseeing a minor or someone that's incapacitated, and making sure that things are being done in their best interest. There's of course custody issues that can come up post passing if you don't have a guardian name for a minor child, or a preference, or a successor trustee, but usually it's a minor. There still need to be a guardian. So the thing that most people think about is the estate, the stuff. And this is a list of types of things that we usually see. There's a whole sub industry now for guns and automatic weapons, and transferring those is tricky. So that's a whole nother separate area of law, but I don't cover that here. Titling. Titling is critical. How do you own stuff? How are you a owner of record? Um, what is first day of law school, real property? I'll never forget a professor that went around the room asking, "What is title?" And it was the purest Socratic method you've ever seen. It was an hour long of torture of people guessing what title is, and ultimately, it's a bundle of rights. And we embarrassed ourselves until we finally got to that final definition. And uh, so titling stuff, how you put your name on a bank account or real estate, that is critical in estate planning for a couple of reasons. There are three ways that you can own property at the time of your passing: individually, jointly with multiple people, or by contract. So some examples there. And that's critical. Why? So if it's individual and you pass, well, now you may need to probate this. Interestingly, bank accounts in Florida, we have a wonderful thing called transfer on death or payable on death. And with that, you can tell the bank by filling out their form that when I pass, I want this to go to so-and-so or these multiple people or into my trust or to my trustee, my successor trustee on behalf of the trust. And then if you follow their form, that next person or next people, they show up with the form and the death certificate, and poof, no probate needed. That's one of the ways that you can circumvent if it makes sense. In certain circumstances, you may want to circumvent probate, keep the account in your own individual name, but then have it go into a trust because you want detailed instructions beyond your passing. Jointly, so jointly, if there's right of survivorship, then it goes to the survivor, the other person. If there is not, then it would go still that person plus with your heirs. So that can be a little complicated. And then by contract, that's life insurance contracts. A trust is actually a contract also. I listed here transfer on death, payable on death. That's statutory. So that's a whole nother little piece that's not critical for titling. That's more critical for you can pick who you want for certain financial accounts only. So I just covered that. So the two main options, will or trust. And the third option that I've alluded to, that there are hybrids where you may do some incapacity planning, some legacy planning, but maybe you don't need a will or trust. And that's case or person dependent. So a will is better than nothing. You can name your guardians, name your beneficiaries. Again, it's a snapshot. The personal representative process these things this way. If there's probating of a will, which there has to be, if there's something that needs to be transferred pursuant to the will, then it's got to get probated. And then that's arguably about a year. That's the guidelines on the Florida rules of court. They have that earmark for about a year, and you have to have a lawyer. Generally speaking, there are some exceptions for that. So that's part of the problems with probate. The will does not provide for any incapacity. Will could have problems if you're crossing state lines. There could be different requirements state to state. Kids get money outright. You can't have any control. There's no one that you can appoint to have ongoing control. It's just these things get transferred upon your passing. That's pretty much it. Not before and not too far after. And there's Tom Cruise. He can't handle the truth. It's expensive, which I'm going to detail here in a second a little bit. It is time consuming. It is public, although it's not that easy to get some things. Some courts are wide open, allowing you to see anything that is filed in a probate. There are exceptions. Inventory, I believe, is one of the stated statutory exceptions, but otherwise, some counties will make it readily available online. Others, you actually have to go and see it, but it is public for the most part, few exceptions. There are statutory parameters for how much a attorney representing a PR gets paid. The PR can get a reasonable fee is the statute on that, but the attorney can get a fee as well, and that's a percentage. And it's the it can be hourly, it can be anything, but the percentage is presumed reasonable. And so we estimate a range 2 to 7%, depending on what's going on. If it's contested, it could be more than that. You could have one of those situations where you're fighting over a relatively small amount of money and you blow past that in attorney's fees. But here's a decent example, some real estate in South Florida. God willing, everyone here on this call, on this Zoom tonight, will live a very long time, and your real estate in South Florida will be worth much more than that. The average prices, it's unbelievable. What we see here in South Florida, but assume 1.5 million for a home. You have some savings, some investments, some life insurance, and a 401k at 3,250,000 is a probatable estate. And we figure even at 1%, it's a lot of money. You could spend a fraction of that and set up an estate plan and not pay any of that, or not have your loved ones pay a dime of that. Granny with some money to burn. There's a great movie, The Dead Presidents, where they make that same reference, money to burn. They rob a Federal Reserve where they're burning old bills. So probate is public. We talked about that. It can be complicated, it can be long. There are times where a will-based plan will be perfectly fine for some people. We certainly do them on occasion, and it's far less than we do of trust and other options. But if there's less than $75,000 or $75,000 or less, you can do a summary administration, which is a petition, and you meet a checklist of different documents and you submit an order, and you're in and out of probate, can be done within a month or so, maybe less if you're doing it really well. If there's anticipated litigation, by the way, you can also do a summary if the person has been passed for more than 2 years. So there are some instances where there is no will. Well, we'll say, you know what, this might get a little crazy. Maybe it's best to wait. If someone's come to me and it's already been a year post passing anyway, maybe we want to wait another year and do a summary. And there can be different reasons for that. Anticipated litigation, you know that there are people who are going to a fight. And you know what? I just would rather have a judge involved right out of the gate. I'm doing a will. If I have a trust and I have to pick one child to oversee a trust with multiple other family members and they're all going to hate each other by the end of this thing, I'm just going to have a judge. And so that can happen. But generally speaking, the better option is the trust. You can name beneficiaries. You can change your mind. You can revoke it completely. And during your lifetime, if it's a revocable living trust, you have full control. I don't want to get too deep into asset protection, but I think it's important to mention that a revocable living trust provides no asset protection while you are alive. When you pass, let's say you're the grantor, you created the trust. When you pass, it becomes irrevocable. And then there can be asset protection depending on who's in control and how it's set up. But that's a common question. In Florida, we have a lot of good asset protection mechanisms, homestead, 401ks, joint titling, tenancy by the entirety. There's some good stuff. If that's something you're interested, I'd be happy to talk to you about that too. So everything you own right now is either owned by you individually or with someone else. You move your stuff into your trust, and that's really a misnomer. The trust doesn't own anything. The trust can't sell anything. The trust can't sign anything. The trust is a contract, essentially. It's a unique, special contract that goes back hundreds of years But the person that has legal control over the stuff when there is a trust set up is the trustee, and the trustee holds it and controls it and does whatever is required pursuant to the terms in the trust. So you hold things in trust. The trustee holds things in trust. But it's so common to say, I want to title the house in the trust. I want the trust, I want to buy a new property in the trust. And it's just not exactly accurate. Very, very common. I see lawyers make that mistake all the time in real estate transactions. You can't have the trust as seller. It's the trustee on behalf of the trust is the seller or the buyer, as it may be. And then, of course, the trustee needs to sign. Okay. Obviously, huge misnomer. And I think a lot of people, I'm surprised that a lot of people that know this, trusts are not just for wealthy people. I get calls pretty regularly from people that are not, I would not consider wealthy or rich, who are setting up trusts for all kinds of other reasons. So the agreement, I mentioned that. That's all it really is. You take away the misnomer or the mystique of it. It's just an agreement. And there's a couple different parties, and there's all kinds of nuance that you can do within a trust. So here's an example. Bob has $100,000 in a bank account. He wants to leave it to Fred, but he doesn't want Fred to get the money until he's 25 or he's graduated college. We can't do that with a will. We can't do that with transfer on death. So we have to create a trust in that situation to achieve those goals. There's the three parties in a trust: grantor, trustee, beneficiary. Harry and Wendy are going to create a trust. They're going to be all three initially. They're in complete control. This is obviously just an example. Going back to how you title things. So this is a great little analogy that I learned along the way. And you think of a trust as like a backpack. You have to put some stuff in the backpack. You can get all kinds of different backpacks. You can pick different colors, sizes. Even now, see-through is required in some schools. So you put stuff in a backpack. The kid carries, your child or whoever it is carries the backpack, and they get to school and they give it to someone else. That someone else is holding those things in trust for the child who's the beneficiary. And so a trust, that's essentially what you're doing. You're putting things in a backpack and you're transferring who gets to control or gets to wear the backpack. No court, can all be done by contract. You do have to put things in trust. This is a common mistake. You form a trust, you sign all the documents, wonderful, everything's set up, but you don't put anything in it. You do not have a trust. It has to have something. And our trusts have a provision that we're putting $10 in to start, so it should never be a problem in our trust. We also do an assignment of all personal property into the trust. You can assign vehicles. I don't recommend retitling them. That's a whole nother topic. We can talk about that if that's an issue or concern. You can transfer generally two vehicles without a will or a trust to a spouse or next of kin, a descendant. If you don't have a descendant or don't have a spouse, or you have more than two vehicles, then we get into the need for a trust or some other ideas. Okay, so there's the titling issue. Jane, it becomes Jane Smith as trustee. So a trust solves all of those things we talked about. It's not expensive. There's no money or very minimal money that's spent post passing, depending on what's in the trust. There could be some trust administration, but generally it is far less expensive and it may not cost anything. Assets go to your family very quickly and it's all private. Under Florida law, if you do not want to disclose the trust terms or the trust itself, there's a provision that says, I'm going to give you a certificate, which is essentially an affidavit under penalty of perjury that says, I, as trustee, have these particular powers. The statute says exactly what needs to be in that. And then you may have to attach just a page or two that gives you the particular power of what it is, like you're selling real estate, and then you record that certificate with the deed and no problem. So we do real estate transactions with trusts involved, and no one needs to see the entire trust. Okay. So things that people worry about, parents worry about after they're gone is that they leave things to their kids and the kids get divorced, kids get sued. That's a very common concern, depending on your children. And you don't know, especially with younger children, how things are going to go. You may not know, even if they're adults, things can change. So this is just another example. We go back to Harry and Wendy. They have two kids, Denise and Sam. Jason is Denise's husband, and they commingle assets, eventually get divorced, and Jason gets half. Sam is a little accident prone. He gets sued. He loses everything to a lawsuit from a creditor. Things that could have been avoided if there was a properly set up children's trust. The children's trust, you put things in a trust with someone else other than Denise and Sam who have control. And that you can have very conservative or liberal, for lack of better terms, wording. We have all different types of clauses that we'll use for these, depending on what the grantors want, to determine how easy or difficult it is for the children to get stuff. Is it just for their health, education, maintenance, and support, HEMS, or is it more broad than that? Is it ages and certain ages and stages? We saw before 25, we saw before when we graduate in college, all kinds of different things that you can do with this. It can get pretty creative. But the idea is that if the children don't have control of the funds and they can't control the distributions, then that money is not touchable. Now, once a distribution is sent to them and there's a creditor, then it could be reached. But otherwise, it can provide great creditor protection. Taxes, that was a big concern. The basic exclusion amount was 13 million and change. Last year, it was set to expire, rolling the basic exclusion amount back to about $5 million. And that was extended recently. So for 2025, as long as you individually have less than about $14 million, there will be no estate tax. That doubles for married couples. So most people coming to see me, taxes are not an issue anymore. When I first started doing this, it was in the hundreds of thousands of dollars, not in the tens of millions. This changed estate planning significantly. There's no Florida death tax either. It's a common question. The gross estate includes insurance proceeds, even though you may not have to probate it for tax purposes, you still need to include it. And there's all kinds of complicated and interesting ways to minimize taxes through the use of multiple trusts, using other states. That's another complicated question for another day. But it's super rare. So incapacity planning. These are the documents while you are alive. A power of attorney is wonderful if you are incapacitated, cannot communicate, and you have someone that you trust, could even be a corporate trustee who acts as a power of attorney, like a bank that has a fiduciary duty to act in your best interest. They get to know you as much as possible. But generally speaking, it's someone you know and trust, that if you're unable to communicate, they have the ability to sign documents. I had a older gentleman in the office this week who was unable to sign. He could communicate, but he understood what we were doing, but he was very close to crossing a point of no return, and it was important that he had power of attorney. We don't know, unfortunately, how these types of things come down. And I've seen so much. We've gotten phone calls with, people in hospitals with this type of situation. So a durable power of attorney, no matter what you do with your estate planning, is very important. Similar to a trust certificate, you can do an affidavit of attorney in fact. It's almost the same thing. And it says, look, I'm not showing you the power of attorney, but under this affidavit, I can tell you I'm authorized under penalty of perjury, and you can rely on that under Florida law. So powers of attorney, durable. What makes them durable is that they survive incapacity. They do not survive if someone passes away. They're useless at that point. But a durable power of attorney is a specific type of power of attorney under Florida law, has to have specific language in it, and it survives even if I no longer have capacity or I can no longer act on my own, then that the agent can still act for the principal. A living will is something under Florida law as well that allows you to say that if I, God forbid, am in a critical end stage condition and I'm only being kept alive artificially by machines, I don't want to live like that. Under Florida law, you can sign that paper and give specific instructions. You can also designate someone to oversee that those instructions are carried out, to not live that way, or to be kept alive only through machines. Healthcare designation is if you're incapacitated, it's like a durable power of attorney, but now it's not for financial. This is for healthcare decisions. And in order to give someone the power to help make decisions, you, of course, they need to speak to the doctor. They can't make an informed decision without speaking to the doctor. And the doctor can't speak to them, to your healthcare surrogate, unless there is a signed HIPAA release. That's a healthcare release under federal law that allows the doctor to speak to your healthcare surrogate. So these are all standard incapacity planning documents. Legacy planning, this is really, to me, a really meaningful piece. All of this is meaningful, but this is a really meaningful piece. This is a piece that we take a lot of pride in. I don't know that everyone does this. We give out journals. We have a few different ones we've used over the years. They give you, like, if any of you had Mad Libs when you were kids, where you fill in like the blanks and then you read from it. It's like that, but not funny or designed to be funny. It prompts you, and there's a lot of filling in the blanks for memories, for things you're grateful for experiences, and of course, things that you want your family to know, important virtues that you want to pass on, cultural issues, pictures you can put in there, you can tape in or glue in with some notes. So it creates a really handy kind of overview that it's a nice keepsake. There are all kinds of things that people do with photo albums, decorative photo albums, digital photo albums, as long as you have a way to share it without a password, great. That too can be great. And we've made so many advancements, like where you can search and you can tag someone's face from an old black and white and then say, okay, now search through this and show me all pictures of that person. And so it'll go through Google, and Apple has this capability. And obviously that's continuing to advance. There are some wonderful new third-party applications, Memento, Storyteller. I have not yet implemented this into our practice. I'd like to, but it requires some tech comfort. So Memento, you're recording your voice, similar to the fill in the blank journal, but you're speaking it, or you're recording a video of it. And then Memento pieces it all together in a nice presentation. Storyteller is similar. So these are third-party apps. Are not super expensive, but I am more often mentioning these to people as another alternative to pass on their legacy. Some additional concerns that we'll help you with: memorial instructions. This is a nice way of saying burial instructions. Digital assets inventory. What do you do with all your passwords, all your stuff? Online books, online music, or electronic books and music. Gifts of tangible personal property. There's some ways that we help make that easy. That can change. You don't have to come back to a lawyer. I want to make sure that so-and-so gets this particular art or jewelry. There's ways that we bake that into our estate planning, so you can add that later or change it later. There's also, that we can discuss the benefit of gifting while you're still alive, of course. There's value in that. We also we store everything electronically, the copies of all your docs. We give you a binder, a three-ring binder with all your originals and give you some detailed instructions along with the book and some other stuff and some other forms that you can do some of the follow-up, like I said about the, gifting on your own later if those types of things change. Try to make it as easy as possible. We also do a yearly follow-up that's free. So we'll send you an email once a year after your estate plan's over. Hey, I can't believe it's been 1 year, 2 years, 3 years, whatever it's been. If you'd like to schedule a free consult to follow up and discuss anything you might want to change or consider changing, you click this link, get it scheduled. And then, of course, if we have to do any work to make changes, we will charge for that. But with the updated consult, we don't charge for. So next steps. Find an attorney. I could not imagine operating on myself. I couldn't imagine doing any other area of the law that I myself don't do, or I'm not extremely comfortable with. So I have done estate plans for my family, for myself. So I'm comfortable that with this area of the law, and I think that's a very, very important um, issue. Obviously, I've been doing this a long time, so I say that just from the standpoint of I read this great book years ago that says if you're not comfortable, doing an area as a lawyer, doing that particular area of practice, then you need to learn more. You need to do something else. So I'm just trying to relay that in the scenario law, I'm very comfortable with. And there's some different questions. I think there's some instincts that we, as we get older, tend to kind of write off, but there's value in that too. You get a feel of someone really genuine. Are they really trying to help me? Or are they just trying to make a buck? Squid fitting a square peg into a round hole. Or is this someone that's really trying to look out for me? And we try to do that with all of our practice areas. Of course, we try to charge fairly, but there is a certain gut after you meet with someone that I think is important to honor. So our process, we do an initial conference. Once everything's signed up, we agree that it's a good fit and we're going to proceed. We do a design meeting. That usually takes place 2 weeks or so after the initial conference. We gives us some time to get all the beginning of the docs ready. The design meeting can take anywhere from a half an hour to an hour and a half, depending on what's going on. And then another 2 weeks or so go by. If we need to rush this, we can. Then we'll get you the draft documents for your review. That'll be usually in a Google Docs setting where you can edit and suggest edits so I can see what's going on. We can schedule more meetings to make changes if need be. And once we get a final set, we'll set up a signing ceremony. Our pricing includes getting a mobile notary and witnesses out to you wherever you are. You don't need to come into our office to do this, but if you'd like to, you don't need to come in office for any of this. This can all be done via phone and Zoom and a mobile notary and mobile witnesses. But if you want to come in the office, great, not a problem. We can get that set up as well. We give you the option when you schedule your design meeting, you also have that option to do it in person, over the phone, or Zoom. We try to be very flexible with that, and our pricing tries to include any of those options for you. There shouldn't be any add-ons with us. And then we talked about the complimentary annual review. Fees, I mean, this is something that is important to a lot of people, obviously, and something that's important to us is that I don't want to charge you unless I'm, one, pretty sure I can help you, and it's in most and I am pretty sure that it's going to save you more money than what you spend with us in fees. I want you to profit from our relationship or benefit from our relationship as much as we can possibly do that. You and or your family. So that's the most common plan: revocable living trust, pour over will, assignment of personal property. If there's minor children involved, children trust. Even if there's not minor children, depending on the age, depending on what's going on, we may set up trusts for descendants within the trust document that generally are not separate. Durable power of attorney, that's the healthcare surrogate, HIPAA waiver, living will. If there's guardians for minor children, we'll help you with the memorial instructions. We usually give a form for that as part of the final electronic delivery of the documents that you can fill out and print. We give you a three-ring binder, we give you the journal, and of course we store everything electronically. There's a link to schedule, calendly.com, EMRPA/PNC. And you can schedule a conference for free. If you are married, then both spouses should attend. We can discuss goals, answer questions, go over some options, go over fees, and of course, decide if we're a good fit for one another. If you book in the next 3 days, we will gladly give you a discount of any estate plan if you decide to go forward. And yeah, initial conferences, I'm pretty good about giving an initial consult. A lot of lawyers charge, and I do charge for some initial consults, but if you've attended the webinar, then I won't. It will be a free consult. Generally speaking, you should be a Florida resident to create Florida estate planning documents. Those are some common, I should change the title of this slide from excuses. It could, it could really could be just concerns or fears. And these are common. Certainly, I don't like attorneys. I can relate with that. I grew up in a family of lawyers. I never understood the lawyer jokes, the bad lawyer jokes. The people I knew and I grew up with, they were all like super into serving people, and they never talked about anything in their practice except problems and how they were looking forward to solving them and creative thinking to get things solved. And then I get out in the world and become a lawyer, and I'm like, oh, now I get it. Now I see there's like everything else, there are some good and bad. But I don't want to go through all of these because hopefully, not all of these apply to everyone, but we can certainly discuss any of that during a consult, any concerns you have. So that's again the link, phone number, email, whatever's easiest. Thank you so much. Again, our practice area is there. I'll leave that slide up for a second. Anyone have any questions? We are at the end of the slideshow. I'll leave the chat open for a second. Of course, feel free to email me or call if you'd rather, discuss it personally. If you ask me a question, I won't say your name. I will just answer the question or read it out and answer it. All right, I'll leave that open for a second. Appreciate you guys coming at 8 o'clock. All right, I got to thank you. My office is in Hollywood. Got a question about fees. Um, you know, I really don't want to answer that question, but I will. It varies. So, if you are not doing, if you're just doing incapacity planning and we're able to do, I didn't mention like a ladybird deed as a way to transfer property without a will or a trust, and then you're doing transfer on death or payable on death for all your bank accounts, or there's maybe a life insurance policy, you're naming a beneficiary. That could be as low as a couple $1,000s. The ladybird deed and the incapacity planning documents, including the mobile notary, we tend to charge around $900 for ladybird deed, and that whole process, getting it set up, we have to record. There can be issues with transfer taxes. So, I don't want to, please don't, hold that against me because every case is different. And a ladybird deed is not ideal for every situation. A ladybird deed, really quickly, is a form of a life estate deed where you're not transferring property now, but you are signing a deed that you will transfer upon your death to person B, let's say. You're A to B upon death. However, you're reserving the right in a ladybird deed that if I change my mind, I can change my mind. If I want to sell, I want to take out a mortgage, I want to do whatever I want, I get to do that and you have no say. A traditional life estate deed, the remainderman, the grantee, the person that will take at death, is vested and has to sign any deed, any sale, any mortgage they have. They're a vested remainderman. In a ladybird deed, you're also vested. These are just legal nuances, but you're subject to divestment. There's some lawyers on this call who appreciate this. God bless us. You are a vested remainderman subject to divestment in a ladybird deed. So the remainder person does not have to sign a mortgage or a deed or anything like that. So, that could be as low as $895 if I'm just doing a ladybird deed. If we're doing some incapacity documents, depends on what. You can figure $500 or so, for per incapacity planning document, and then trusts, a will based package with all of it. We try to aim to be around 3,500. And trust, we try to aim to be around 4,000 or so. If we're transferring title to a property to be held in trust, then we generally will include that in our pricing, and we may charge a little more, but I try to get it around there, 4,500, 4,250, 4,000, and it depends. So it varies. Don't hold me to it, please. Um, but the person who asked is someone I know. I know wanted to answer. So there you go. You got it out of me. Any other questions? And thank you for asking. That is a very, very common question. What are the fees? Someone else asked about the office. We're located in Hollywood, but we can help you anywhere in the state of Florida, really anywhere. So, if you're a Florida resident, but you're signing documents while you're in Alaska, we'll make arrangements to get the document signed in Alaska, as long as you're actually a Florida resident. Not a problem. All right. Very good. Well, thank you everyone for attending. Much appreciated. Again, feel free to reach out with any follow-up or questions. I hope you guys will all schedule a consult to dig a little deeper, and look forward to seeing you and speaking and hopefully helping you. And thanks again.